Welcome to Education in Focus. I'm your host, Aliana Kernodle. A federal judge dismissed a lawsuit brought by a group of Jewish parents and teachers claiming an ethnic studies curriculum allegedly taught in Los Angeles Unified School District classrooms was anti-Semitic. Joining me to dig into this is Chalkboard News editor Brendan Clary. Brendan, what is the background on this lawsuit?
Yeah, the background is that the lawsuit was brought in May of 2022, and it was brought by parents and teachers who are Jewish and Zionists, so that they believe in the state of Israel and that that's a foundational part of their Jewish, sincerely held religious beliefs. So both the parents and the teachers either work at Los Angeles Unified School District or have students who attend Los Angeles Unified School District, according to the court documents. So that's kind of the origin of this. And again, this is before the October 7th attack by Hamas on Israel. This was back in 2022. And they were challenging what's called the Liberated Ethnic Studies Model Curriculum. So something kind of to know is like there's a lot of these different kinds of model curriculums or different things that are implemented by people who are outside of a school district. And maybe they have like, here's a best practices for this social studies. Like maybe it's like a specific kind of history group organization that creates like these, best practices for, social studies, for example. And so you'd have different kinds of entities who will create, model curricula. And in this case, there was an organization called the Liberated Ethnic Studies Model Curriculum Consortium, which is actually who created the curriculum. And so they were named as a defendant and were the primary defendant, so who was being sued, along with the Unified Teachers of Los Angeles and also the school district. And there was also a teacher who was named in this litigation. So those are kind of the background of, who, and then what is alleged as having happened is that this curriculum was anti-Zionist and basically was trying to, quote, expunge the idea of Zionism and the legitimacy of the existence of the state of Israel. And there's other allegations that there was, quote, rank discrimination embedded in the curriculum because the curriculum, among other things, includes, quote, statements that the existence of the state of Israel is based on ethnic cleansing and land theft, apartheid, and genocide, and that, quote, Zionism is distinct from Judaism. And so it kind of gets into some of these cultural questions that have come up quite a bit since October 7th, 2023, and something that has kind of played out in some of the public school debates about, whether to teach, these ideas that are potentially critical of Israel's role in its response to the October 7th terrorist attacks against Israel. That, basically some of the cultural fight has been like, is it anti-Semitic to criticize the state of Israel? And that's been one of those hot button things where Jewish teachers specifically, and there's another case too, where teachers in the Los Angeles Unified School District have sued the state public education board, or like the public employee board, that's called PERB, California, the Public Employee Relations Board. They're suing that and saying that it violates their deeply held religious beliefs to be forced to be part of the union, UTLA, because of its promotion of anti-Zionist and by extension, they argue, anti-Semitic ideas. So that's what one of the pushbacks to those who are criticizing Israel is saying that to be like critical of the state of Israel and to be critical of a state of Israel is to undermine their deeply held religious beliefs. So that is something that we've seen, recently in those lawsuits. And that's some of the controversy that's behind this, right? And the judge, when dismissing this, said that is part of what the lawsuit is asking, is asking the court to decide, like, is that anti-Semitic or not, to be critical of Israel, or to be like anti-Zionist, is that anti-Semitic? And it just said, we're not going to weigh in because we haven't had, what's called the statement of claims.
So can you get a little bit deeper into this? Why did they dismiss the case? What were sort of the details of that and the reasons behind it?
Yeah, it gets really, really confusing pretty quick just because, the courts don't talk the way that most people do, right? So you have to kind of get through some of the legal language there. Essentially, what the parents and teachers were asking the court to do was say, we need to stop teaching this curriculum because it violates our deeply held religious beliefs and it is, anti-Semitic. And so that's what they were saying. What the court said is essentially you are saying that this is being taught, but you can't really prove that it's being taught to your students or in your classrooms. And so you can't actually show what's called injury. So in the legal terms, like you have to be able to show that like a policy or like something that you're challenging is actually hurting you. And they were not able to show that effectively, the court decided. So that's kind of the main crux of that, is that they couldn't show that they had the legal foundation to say like we challenge this, because the court said like you're not really getting that hurt by it. Like that you can be offended by this, but that doesn't mean that it's hurting you in any way or limiting your right to practice your religion at home or even in the school district while you're at work, or it doesn't affect you, if you're a parent, it doesn't affect your children to hear this offensive material, even if you find it offensive. The other thing too is that LAUSD hasn't like officially adopted the policy. Like there are some teachers who've said, I'm teaching this to my students, but by and large, the school district hasn't like said, yes, we are going to teach this model curriculum as our liberated ethnic studies. Basically, the court found that the parents don't identify any burden at all, and it does not allege that plaintiffs have somehow been prevented from practicing their faith, or that the parent plaintiffs have been barred in any way from instructing their children at home. Quote, in effect, the only hardship plaintiffs allege, the parents and the teachers allege, is that the existence of the challenged curriculum and its possible adoption offends them. And then the mere offense is insufficient, the court said, to allege a burden on religious exercise. So like, it doesn't really matter if you're offended, but it hasn't moved to that next level of saying, this is violating your speech and we can't shut it down. And it also got into some of the what would actually happen, like what would relief look like in order to shut this down. And they said that would be potentially unconstitutional because they would have to manage like what is and isn't allowed to be said in a curriculum, or like what can school districts teach. So it gets into some of that of like, how would you fix this then too? And the court said like, we can't get into this.
Well, Brendan, thank you for your insights on this story. And I'm sure you'll continue to follow this story and the other ones you mentioned addressing similar issues in Los Angeles. Our listeners can keep up with these at chalkboardnews.com.